Peter Schellenburg was using a grinder when he encountered an accident. The grinder obtained its power by means of compressed air driven by a compressor through a high-pressure hose to the instrument. One of the couplings on the high-pressure hose became loose or detached, which caused the air to rush out of the hose and caused the hose to flail around uncontrollably. This was a very dangerous situation, and Peter dodged to avoid the hose. His violent dodging action badly damaged his back, and he sued his employer for negligence. In proving negligence, Schellenburg relied on a doctrine called in Latin res ipsa loquitur, which in English means the thing speaks for itself. This is an old doctrine where a party argues that something is so inherently obvious that it need not specifically be proved. Schellenburg argued that the negligence of the employer was so obvious from the decoupling of the high-pressure hose that it need not be specifically proved. The court summarised the considerable previous authority, setting out 3 rules which must be followed by a party seeking to rely on res ipsa loquitur. Those were 1. An absence of explanation of the occurrence that caused the injury. 2. The occurrence was of such a kind that it does not ordinarily occur without negligence. And 3. The instrument or agency that caused the injury was under the control of the defendant. Schellenburg, unfortunately for him, was in trouble in relation to each of these factors. The evidence suggested that there was plenty of material to explain the injury, that sometimes these hoses came off their couplings without negligence on the part of anyone, and that in this particular workplace, Schellenburg himself was in charge of the hoses. It followed that he could not rely on res ipsa loquitur, and that he had not proved negligence on the part of the employer. His claim failed. Some of the judges, particularly Justice Gaudron, went into great detail about the doctrine itself. There was clearly a significant lack of enthusiasm among the judges for res ipsa loquitur to continue. Indeed, Justice Gaudron said, "Perhaps res ipsa loquitur will continue to linger for a time as yet another indication of the attraction of lawyers to exotic labels." Regardless of this lack of enthusiasm, the case stands as authority that res ipsa loquitur can still be relied on if the 3 elements are met.